Minister, I want to raise an issue with you in relation to section 13 of the bill, and apologies, my amendments were actually late for committee stage because committee stage was to be next week and then it was brought forward to this week and I missed the deadline, but I will be submitting amendments to subsection 7 and subsection 10 for report stage of this bill. As you know, Minister, during the discussion that we had on the Sex Offenders Amendment Bill, I tabled amendment number 27 in relation to the harassment of victims for which a perpetrator was already charged, convicted and served their sentence. Now, we're both aware of a particular case in relation to persistent harassment, and the difficulty is under the proposed Sex Offenders Act, the orders post-release won't be able to address the issue of persistent harassment, and I know it's your intention through section 13 of this bill to try and address that issue, because at present there is no way that the victims can actually be protected from secondary or repeated victimisation, intimidation or retaliation by a convicted offender. Now, while I welcome section 13 of this particular act, I think there are weaknesses in relation to it, Minister, and I'd like if you could consider these in advance of report stage. And the first one is that if the original conviction is held in camera, then any prosecution or proceedings under harassment in relation to someone that's already convicted needs also to be held in camera. So, as you know, in relation to sexual offences, they're held in camera to protect the identity of the offender, of the victim, and the offender's name and details are not released for that purpose. However, if under the harassment legislation this is not held in camera, you are effectively closing off the opportunity for any victim of a sexual offence to actually go before the courts and get protection in this area. So the point I'm making to you here, Minister, is that if the original proceedings and conviction were held in camera, the harassment proceedings need to also be held in camera. The second amendment that I would ask you to consider is the maximum sentence provided for in terms of an order under section 13, and that is that sentence should be able to comply with any order that has already been placed through the sexual offenders amendment legislation in terms of a term that an individual has an order under that act or must comply with the sex offenders register. So it would be important that any order in relation to harassment would run in tandem with previous orders already made in terms of the length of time an individual must remain on the sex offenders register, or in relation to other orders that have been made at the time that they were convicted, or subsequent orders that were made under the new Amendment Act. Thank you.
Very good.
Thank you, Deputy. Maybe just to respond and appreciate the timelines and the changes, so I'm happy to look at some of these further. In terms of the in-camera, I suppose there will always be situations where particular cases should be held in camera and it's separate. So now we keep moving from different bills. We've had the sex offenders on this, and obviously we discussed some of these elements in Coco's Law as well. In the sexual offences bill, what we are expanding is that all sexual offences, not just rape, would be held out of the view of public, obviously allowing for media to be conducted in an appropriate way. In terms of the civil orders in particular, which I think will deal with a lot of cases where you have a subsequent offence happening post somebody who has served a term and something is happening afterwards, they will always be held in camera, the same as any family court or any other type of setting. So just to be clear that the civil orders, which I think some people will opt for instead of having to go through the criminal trial, they will always be in camera. But specifically looking at stalking and harassment, it's something that I'm happy to consider further. The two of them are not explicitly stated within the sexual offences bill that we're progressing at the moment, but I think it's an area that we could explore and see. I'm not sure it would cover all types of harassment, because not all types of harassment would have a sexual nature to it. So I think we just need to look at whether one or both could potentially fit into that. But again, as I said, it's something I'm happy to explore. But just to be clear, the civil orders that we're introducing in this would all be in camera, the same as any other family court, and hopefully that would give some peace of mind to people. In terms of the consecutive sentences, as you've mentioned, there's nothing to prevent that from happening. But also, if you look at the new section 10.7, it provides for an aggravating factor. So a judge must take into account where there is a previous offence, and they must apply a higher sentence based on that. So it's not that they would be disregarding previous offences, but there's nothing to prevent what you've suggested from happening as well in this legislation. So I'm not sure there's actually anything we need to do there, but just to acknowledge that there has to be a higher sentence imposed where there has been a previous offence, and the judge must take that into account.
Thanks for your response, Minister, in relation to that. The issue I have with the second aspect in terms of the sentence, for example, in relation to a safety order that's under the domestic violence legislation, it is extremely unusual for a safety order to be put in place for the maximum of 5 years where there's agreement. It's usually on average of 3 years. It's only if there are aggravating factors that it is put in place for 5 years. And the concern would be that you would have an offender who, and look, the difficulty is the individuals that we're talking about here are a small cohort of the offenders that have gone through the process, but they are individuals who will exploit every single loophole in the legislation. They are individuals who are manipulative and wouldn't have been convicted in the first place if they weren't manipulative in relation to the victim. So what I don't want is a situation where they can use some wriggle room in it, where they may have an order that they're on the sex offenders register for 5, 10 years, permanently on the sex offenders register, but they have a minimal provision in relation to the issue of harassment, which puts it back on the victim again, that once that period of time has elapsed, 3, 4, 5 years, whatever the case may be, they have to be vigilant again. They have to go and collate evidence again and then go back to the courts again. Now, to me, Minister, and from the discussions we've had previously in relation to the sex offenders legislation, I believe that that's a further exploitation and abuse of the victim. And I think we need to minimise that. Like, it should not be tolerated whatsoever that there is harassment after an individual's release from prison. And if an individual is forced into the situation that they must go before the courts to get protection and to get a specific order put in place, then it must be for the maximum period possible. And there shouldn't be wriggle room in relation to that if they're exploiting an individual that they've already exploited before this. Thank you.
I suppose what we always have to be mindful of is these are two different sentences potentially being applied, or two different scenarios. I appreciate what we're talking about is a follow-on form of harm subsequent to significant harm that's already been caused. The applying of be it a civil order or be it a conviction for harassment or stalking is to protect somebody immediately. So you want that to apply immediately, not at the end of perhaps a time frame that's been given to be on a sex offenders register or otherwise. But there's nothing to stop that from being extended, either the Gardaí applying or the individual themselves, if after, say, the maximum period of time that behaviour is still continuing. If it's a civil order that's applied, then obviously there's nothing to stop them applying for a criminal order as well, where you would potentially have a higher sentence. So it falls into, I suppose, the challenge between obviously having to separate where somebody has been convicted of a specific charge and then applying a separate charge and not conflating the two. But the very fact that somebody, the judge in particular, has to take into account where there has been a previous case and apply the maximum sentence, that does take into account what's happened previously. but saying that it has to be for the same period of time perhaps as the initial one, when they're two different sentences, or they're two different situations. I suppose they're different, and they have to be applied in a different way, and that's why the sentences are different, because of the severity. So again, there's nothing to stop a judge from applying sentences in the way that you've set out. However, what you want to make sure is that it's actually put in place immediately, that the victim is supported immediately, and if it needs to be extended then beyond that, there's nothing to stop, as I said, a member from Garda Síochána from looking for an extension without the victim themselves having to go through that process again. And we've made that very clear, that it can be the guard that applies on behalf of the person as well, so they don't have to go through any court process or any situation like that.
Yeah, and I accept that, Minister. I'm not going to dwell on the point now, but I accept the point that you're making, and I think it is a progression that a member from Garda Síochána can look for that extension. But the reality is that that individual is effectively on tenterhooks from the minute the order is put in place, because they have to continually collate evidence if the harassment is going on. Now, it is bad enough that the harassment is going on, but the trauma that's actually involved for any individual that is exposed to harassment and then actually has to go through the physical process of actually collating that and relaying that to a member of Garda Síochána or whoever is collating it for them, their own legal representative. That's a further trauma again in relation to it. And what I'm trying to do here is trying to circumvent that. You know, I don't have a simple answer to it, but that's what I'm trying to circumvent, is that, you know, if they get an order, they shouldn't have to be continually wary and vigilant and be collating information and evidence to be presenting to the Gardaí to get a further extension of this once this particular incident lapses. And like, the reality is, Minister, in practical terms, what will happen is, even if the individual continues on the harassment, within probably 6 months of the lapse of that particular order, they'll steer clear. And the Gardaí will say, yeah, look, but he has behaved himself, and it's usually a him, but can be a her as well, have behaved themselves for the last 6 months. Let's see what happens, you know, in the next 6 months. And all of a sudden, that victim is being re-victimised again. And that's what I want to try and avoid. So, look, Minister, I'm going to put forward the amendment for our report stage. I don't have a simple answer to this, but I'd ask you to give it thorough consideration between now and report stage of the bill. Thank you.
Thank you, Deputy, and I think we can probably leave it there, because I don't think the Minister needs to come back particularly. I note your intention to table an amendment at report stage, and I'm sure perhaps the parties can engage between now and then to see is there anything that can be worked out, and revisit it then at that point. So in any event, for now, I put it that section 13 stand part of the bill. Is that agreed?